Hello, everybody. Um, so as it was Nana's proposal initially that I talk about the Kosovo Specialist Chambers and the Kosovo Constitution. Yeah. So as many of you know, the process of the Kosovo Constitution making basically was strongly influenced by external factors. It was not a total influence as in the case of the Dayton Agreement, where basically the population had no influence whatsoever in the enactment of the agreement itself, let alone the Annex 4 of the agreement, which contained the constitution. I would say that in the Kosovo case, we had a bit of not a marginal influence, but quite a strong influence in the process of constitution making, whereby the Ahtisaari plan, with as you know, with 12 annexes, were incorporated in the Kosovo Constitution that was adopted in April 2008. When it comes to then the sources of constitutional law, of course, the obvious source of constitutional law is the Declaration of Independence, that, using Schmidt's words, it's the constituent power. It encapsulates the most fundamental act of self-determination of people. And in fact, it was on the basis of the Declaration of Independence then that the Kosovo Constitution was adopted. Another point of reference, I think, I should also note that basically none of these documents, and I would highlight that even Ahtisaari plan didn't say a word about what will come later as these specialized chambers. So neither the Ahtisaari plan nor the Kosovo Constitution contained any word or indication what will come out later as a specialized chamber. But speaking about the sources of constitutional law, another point of reference, I think, are also the decisions of the Kosovo Constitutional Court, formally at least, as our court, as you may know, exercises what is called in the constitutional theory an abstract norm control. And it was then when the amendment number 24 actually was crafted, it was initially referred to the Kosovo Constitutional Court to actually to ensure that the proposed draft amendment complied with what we have, Chapter 2 of the Kosovo Constitution, which relates to human rights. So this is basically just to give an idea as to what the current sources of constitutional law in Kosovo are, and to point out to the fact that, in fact, what has proceeded after the enactment of the Constitution and the proposed constitutional amendments have gone through the filters of the Kosovo Constitutional Court. I should also point out, it might be interesting to note that when the Ahtisaari plan was in the Constitution, you know, we had a very interesting constitutional sort of structure or regulation, since according to it was I think it was Article 143 of our Constitution, which provided that notwithstanding other provisions of the Constitution, it is the Ahtisaari plan. We call it the comprehensive proposal that has superiority or supremacy over the rest of the constitutions. But that was so until September 2012, where basically the 22 constitutional amendments were passed by the Kosovo Assembly, which then brought what we had in international supervision of Kosovo's independence to an end. What our constitutions, we didn't have not only a migration of constitutional ideas, of course. If one looks at the particular provisions of the Kosovo Constitution, one finds an influence of, as I say, external actors, various international organizations, even doctrines of American constitutional principles, such as the principle of separation of powers. Although in content or reading critically the provisions of the Kosovo Constitution, one clearly finds more features of a fusion of powers rather than separation of powers in our parliamentary republic. The parliament, as you know, is vested with legislative power, while the president represents the unity of the nation. The government has been tasked with executive power, and the Constitution contemplates that the judicial power is unique, is independent, and is exercised by the courts. So it doesn't say anything more than this. It also contemplates that there will be a constitutional court, as I mentioned, which will be in charge of rendering interpretative judgments on constitutional matters, but also then going back to Article 113, which lists the competences of the Constitutional Court. There is a variety of competences with which the Constitutional Court of Kosovo has been equipped, and it's interesting that Article 20 of the Kosovo Constitution speaks about delegation of serenity. It says that the Republic of Kosovo may, on the basis of ratified international agreements, delegate state powers for specific matters to international organizations. Now, the Constitution, as such, gives no indication as to whether this means a partial transfer of judicial sovereignty as well, which is not that typical for national constitutions, for the states to transfer this, except for one can argue that, well, if you sort of ratify the ECHR, or if you ratify the EU treaties, then of course you will be bound by the decisions of those supranational judicial bodies. But still, what we have entered into now, following the enactment of the Amendment 24, is basically it results clearly that we have given a bit of our judicial sovereignty to another, I don't know whether I can use the word international court, because I'll argue that the specialist chambers have clear features of an international court. I'll skip this. I'll proceed to the Amendment 24 related to the specialist chambers. Now, the question is why we had to amend the Kosovo Constitution in order to accommodate somehow this specialist chamber and the specialist prosecutorial office in our Kosovo Constitution. What have been the reasons? It is interesting to note that in the Kosovo Constitution, in a chapter which relates to the organization of judiciary, it is explicitly provided that the parliament, on the basis of law, can create specialized courts, but no extraordinary courts can be established. But it seems that it seems that what we have seen so far, and sort of knowing the content of the Council of Europe's Assembly report, the Martis report, and the basically and the intention of the international community, it was that the current norm, the current constitutional norm that I mentioned, was not sufficient, was not enough to incorporate or to allow the creation of such a robust sort of court, which, as we will see, will create a parallel, even a horizontal, but also a vertical structure in the Kosovo's overall Kosovo's institutional structure. So I think that one of the reasons was that there was no sufficient constitutional ground in place to allow or to enable the establishment of such tribunal on the basis of the Constitution. And I'll mention why, because let's say, as we will discuss it later, the specialist chambers, according to the amendment, but more concretely on the terms of the law on specialist chambers, will have or has been given a legal personality, powers to engage and conclude agreements for international legal cooperation, which normally in a normal situation, those agreements should be processed and should be ratified in the parliament. The situation that we have now, the constitutional situation, is that basically the parliament has no say whatsoever with regard to the conclusion and with regard to the ratification of those international agreements, which bypasses clearly what we have Article 18, Article 19 of the Kosovo Constitution related to those agreements that are ratified by 2/3 of the members of the parliament. So we have a problem here. The other problem that we have with regard to the Amendment 24 is that there was no open, transparent debate about the proposed constitutional amendment. Normally, in a proper functioning democracies, people, citizens, various internal actors are notified about the content. They take part in the discussions. There is an openness in the process of the enactment of such constitutional amendment. But as you know, there was no such debate held, and as Mr. Kurti clearly indicated, that after a failed attempt in June 2015, it appears clearly that our MPs were simply forced to vote the draft amendment after the Constitutional Court indicated that it is in compliance with the Kosovo Constitution. So here we have also another concern, a constitutional concern, because that the process of constitution making lacks really this legitimacy of the people in the process of constitution making. So we have here now ranging from the model of enactment of the Kosovo Constitution, where I wouldn't say that the external influence was marginal. Here we have quite a a la Dayton, a sort of a total control of the overall constitution-making process, but also when it comes to the enactment of the law on specialist chambers, which was adopted, as far as I know, on the same day in a package. Yeah. Furthermore, as you can see, the law interferes somehow, or you see, we have a detachment here from what our Constitution says. Our Constitution does not stipulate in any provision, explicitly at least, what the law hierarchy in Kosovo is. Of course, it derives from the Kosovo Constitution, but you don't find any constitutional provision that stipulates what's the hierarchy of laws in Kosovo is. Here, the law on specialist chambers has clearly introduced what they call it the foundation principles, and although it recognizes the Kosovo Constitution's having supreme, which is being the supreme law of the land, it has introduced that this law, meaning the law on specialist chambers, is the lex specialis law, and other laws can also be applied as provided by this lex specialis, including customary international law and international human rights law, especially with regard to the standards related to especially with regard to the standards of ECHR and ICCPR, which relate to the criminal records. As this year, we have also a what we call it an inconsistency between the main text of the Kosovo Constitution and the law, and as Article 162 of the Kosovo Constitution, which is basically the Amendment 24, has put it. This is the prevailing situation with regard to the legal hierarchy of acts that this law has simply introduced in our system. Yeah. Furthermore, what's interesting to mention is that the Amendment 24 has also introduced a specialist, a specialist chamber, a panel of 3 judges that will deal exclusively with matters that will be referred to that panel by the specialist chambers, and on matters related to that jurisdiction. Now, here we have a sort of a parallel judicial structure. So on one hand, we have it is true that the law states that there will be courts set up according to the judicial hierarchy in Kosovo, meaning that the basic court, the Court of Appeals, and the Supreme Court. But still, these acts, in my opinion, act in parallel to the Kosovo judicial system. And they are seated in The Hague. There is no, in my opinion, constitutional organic links between these courts and the specialist chambers. So here, then we end up in a situation where basically this is what Article 4 of the Kosovo Constitution states, that the system is based on the separation of powers, and that the judiciary is centralized, is unique. In fact, having this amendment in place, one can doubt whether we have a unique and integrated justice system and judicial bodies because of this. Clearly, of a parallel, as I put it, vertical structuring of these judicial bodies. And I already mentioned the chambers have a legal personality. They have not only legal, they have full legal and juridical personality. And then when it comes to judicial cooperation, witness protection, detention, and so on, so they can engage, they can enter into agreements with various states. So and this basically, as I put it, this totally. Sorry, what I'm doing. Yeah, and this this basically then raises the question as to whether these courts have a status of being subjects of international law, and as I mentioned, they clearly bypass the Article 18 of the Kosovo Constitution, which clearly spells out basically the conditions upon which those agreements related to participation in international organizations, and when it comes to human rights, are to be ratified by the Kosovo Parliament. Now, another issue that I think I should mention is the rules of procedure. As you know, the plenary of the chambers have already adopted rules of procedure and evidence in accordance with the Kosovo Constitution. But what appeared to be a concern was that in basically in the course of the review of the rules, there were about 208 rules that have been reviewed by the special panel of the Kosovo Constitutional Court. 9 rules were declared to be incompatible with the Constitution. I have highlighted only 2 norms or rules. Rule 19 related to the absence of the judges, where basically the court found that notwithstanding the limited duration of a judge's absence or the views of the parties to the proceedings, the continuation of a hearing before 2 judges of a panel has no basis in law, and thus such a hearing would not constitute a hearing before a tribunal established by law. The other one is related to rules that, in the opinion of the panel of the Constitutional Court, violated clearly the right to privacy, as the initial draft simply had sort of foreseen special investigative measures, Rule 31, 32, and 33. And it is interesting to note that the court stated that it is doubtful that rules 31 and 33 permitting covert interception of communications as adopted by the plenary are sufficient to meet the relevant standards required to ensure their compliance with Chapter 2, including Article 55 of the Constitution, which relates to the limitations of constitutional rights. I have just 2 more slides, and then I'll stop. It's interesting to mention that the panel has also came up with 3 interesting guiding interpretative rules. The first one that it's interesting to observe, because this has not been the case, or at least that much, in the Kosovo Constitutional Court when it comes to the manners and techniques or principles in the interpretation of constitutional rules. The first one is the principle of strict constitutionality, where the court held that a rule to be, so the court does not hold the rule to be unconstitutional unless the unconstitutionality of a provision is clear. That was the first one. The second one is, as you know, the principle of textuality that the plenary has referred to. And it's interesting to mention that the court has or came up with an idea or the doctrine of harmonious interpretation, whereby provisions of individual rules should not be construed in isolation from other parts of the rules, but rather should be construed so as to harmonize therewith. The conclusion, basically, these are some of the conclusions. In fact, they could also be sort of open issues to discuss further, but it is clearly that the specialist chambers have all the features of international tribunals, and it's interesting that these international judicial enterprise, so to say, came up after I'll say that after a clear failure of UNMIC, of EULEX, of the panel 64 regulation, that also it was quite a hybrid court to deliver justice in post status Kosovo. The second, I think, concern that was legitimately raised by locals was that the process was not inclusive, the process was not transparent, and so that basically that is the reason why there is so much doubt and questioning about the constitutional legitimacy of the amendment 2024. The third one is that with this amendment in place, basically, we not only have an international court in place, but we also have as I said, parallel structures in place that may that have been injected in our constitutions and operate quite independently from the rest of the local judicial bodies. Now, we all know that our constitution, but also the preamble, is quite open towards international law. Our preamble of the Kosovo Constitution has clearly invited an international presence in Kosovo, and it also states Kosovo's aspiration to basically get engaged in the EU integration process. But at the end, the question is basically, what remains is basically now using Robert's words. It remains to be seen what narrative the specialist chambers will follow, or whether is it that the ICTY narrative or Dix Marty narrative. I mean that remains to be seen what the court's attitude or position will be with regard to those narratives. That was it.